All right, good afternoon. I'm still Martha Minow, Dean here. That was a fantastic panel and has launched what I know will continue to be a very stimulating and riveting day. We are so honored to have as our keynote speaker Judge Juan Torruella, who is such an expert on the subject that we have here, but I'm going to talk about other things about him. He has presided over two courts, the United States District Court for the District of Puerto Rico. He was chief judge there, and he was also chief judge for a time and still judge on our First Circuit. He's issued over 1,500 published opinions. His Bachelor of Science degree in economics from Wharton at University of Pennsylvania, his law degree from Boston University, his master's degree from University of Virginia, his public policy degree from the University of Puerto Rico, his master's from Oxford. That's the beginning of the explanation for a question I've always had, which is, how did he get to be so learned? I mean, I don't know anyone who knows as many words, just seriously, words, as our keynote speaker. And his wisdom is well known. I'm going to get out of his way because I really want you all to have the chance to have maximum amount of time with him. So please join me in welcoming.
The words I can attribute to my law clerks. I feel that I should start today with something that I learned this morning. I knew it in English, but this morning I learned it in Latin from Dean Rivera. What the gladiators said when they entered the arena. Morituri te salutamos. We who are about to die salute you. Because I have a feeling that what I'm going to say has something to do with with this statement. But good afternoon to all of you. It is a pleasure to be and an honor to be here today. And I thank Dean Minow and the other members of the faculty, Newman, Brown, and Fallon, for giving me the opportunity to share my thoughts with you on the subject of the insular cases and how they impact negatively, in my opinion, the relationship of this nation with the nearly 4 million citizens of the United States who reside in Puerto Rico. I will present my views on the colonial condition that has been in place for 116 years as a result of the regime that was established by the insular cases. Needless to say, I am, of course, expressing my own views and opinions, and no one else should be held responsible for them. I should add that I do not feel inhibited in expressing my views before this gathering because, with some few exceptions that will become apparent before I finish, almost everything that I say here today I have previously stated officially. Somewhat related to this caveat, and also for reasons that will become apparent later during the course of my comments, I should state, this may be known by most of you, but I'm going to say it to be sure, I was born a citizen of the United States in Puerto Rico, which is my home, and where I have my residence and domicile. Getting to the subject at hand, in a nutshell, the insular cases represent classic Plessy v. Ferguson legal doctrine and thought that should be totally eradicated from present-day constitutional reasoning. The insular cases were flawed ab initio because first, they directly clashed with the Constitution. Two, were disobedient to controlling constitutional jurisprudence in place at the time. And three, contravened without exception every single historical precedent and practice of territorial expansion since the beginning of our nation. There is, of course, an additional powerful reason why the insular cases should be disavowed by the Supreme Court. And that is because the principles that they promote run contrary to the express provisions of international treaties entered into by the United States, including, but not limited to, the International Covenant on Civil and Political Rights, which I will refer to as the ICCPR later on in my remarks. And this has been the law of the land since its ratification by the Senate on June 8, 1992. Lastly, but perhaps most importantly, even in today's cynical world, the insular cases should be soundly rejected because they represent the thinking of a morally bankrupt era in our history that goes against the most basic precepts for which our nation stands, which is the equality before the law of all of its citizens. I guess by now you know that I don't like the insular cases. It is appropriate that this gathering take place here at Harvard, for it was here, and to a lesser extent at Yale, that we find the intellectual origins both of the insular cases and the discriminatory rules that they purposely promoted to keep the several million residents of Puerto Rico and the other territories, and in the case of the residents of Puerto Rico, who became citizens of the United States in 1917, in an inferior colonial status. These policies did not come about by chance or accident. For as Reuben Francis Weston, in his book, Racism in U.S. Imperialism, convincingly states, and I quote, and this is a long quote, but I need to state it so you understand. Those who advocate overseas expansion face this dilemma. What kind of relationship would the new peoples have to the body politic? Was it to be the relationship of a Reconstruction period, an attempt at political equality for dissimilar races? Or was it to be the Southern counter-revolutionary point of view, which denied the basic American constitutional rights to people of color? The actions of the federal government during the imperial period and the relegation of the Negro to a status of second-class citizenship indicated that the Southern point of view would prevail. The racism which caused the relegation of the Negro to a status of inferiority was to be applied to the overseas possessions of the United States. There's ample evidence to support Weston's account. To give just one example, let me quote Simon Baldwin, at the time a Yale professor, in his article published at the Harvard Law Review of 1899. According to Baldwin, quote, "It would be unwise to give the ignorant and lawless brigands that infest Puerto Rico the benefits of the Constitution." Let it be noted, I object to his referring to my grandfather in that fashion. And, in fact, his IQ allowed him to enter an Ivy League school. I'm not going to say which one. Actually, at the time the eminent professor from Yale made these derogatory statements about Puerto Rico, nearly 400 years had passed since the founding of Puerto Rico's capital, San Juan, in 1509, which means that Puerto Rico's capital city predated the Pilgrims landing in Massachusetts by over 100 years. And when the troops landed in Puerto Rico in 1899, the year before Professor Baldwin characterized Puerto Rico as ignorant and lawless, Puerto Ricans were already full-fledged Spanish citizens with equal voting rights with other Spanish subjects, including representation in the Spanish Parliament, where Puerto Rico was entitled to 15 delegates and 5 senators. And notably, these are rights which, as we all know, have yet to be achieved after 116 years of U.S. sovereignty. Articles like Professor Baldwin's and others by Harvard's own Langdell, Lowell, and Thayer provided the academic ammunition for what eventually became the Insular Cases Doctrine. There are a series of 10 or 12 articles from Yale and Harvard of that time period in which you see the various opinions that eventually became the Insular Cases. The doctrine, which was concocted out of thin air, created two kinds of territories. First, incorporated ones, which, as it turned out, were only those acquired prior to the Spanish-American War, included Hawaii and Alaska also. And second, the unincorporated ones, which by coincidence, and I use that sarcastically, all happened to have been annexed after the Spanish-American War, and which included Puerto Rico, the Philippines, Guam, and later the U.S. Virgin Islands, which the United States acquired by purchase from Denmark in 1917. So it is clearly apparent to me that the Insular Cases Doctrine, which held that the Constitution did not apply in full force to the unincorporated territories, and instead extended only to a certain subset of rights deemed fundamental by the court, was tailor-made to squarely fit into the racist views that I have previously described, that were prevalent throughout American society at the time, particularly in the circles of power. Importantly, under the Insular Cases Doctrine, Congress was bestowed with, quote, plenary power, end quote, to govern both kinds of territories, pursuant to the so-called Territorial Clause of the Constitution. Thereafter, in a corollary to the Insular Cases, the Supreme Court ruled in 1922 in Balzac versus Puerto Rico that not even the granting of U.S. citizenship in 1917 to the inhabitants of Puerto Rico changed their constitutional rights as long as they remained residents of Puerto Rico. According to Chief Justice Taft, and I just have to digress as to this Chief Justice Taft. Chief Justice Taft had been governor of the Philippines in the middle of his insurrection a 3-year insurrection in which the United States lost more troops than in the entire Spanish-American War. He had also been president of the United States when Congress, or I should say he, and his administration had a run-in with the Puerto Rican legislature over the appointment of a federal judge, and as a result of which the Puerto Rican legislature refused to approve the budget, which was their right to do under the Foraker Act that governed Puerto Rico. He then proceeded to go before Congress and say that it was clear that Puerto Ricans had more rights that were good for them. So he had already a record as to Puerto Rico. Also, when you read Balzac, you will denote there's definitely a racist tinge to this decision. Anyway, Justice Taft decides in Balzac that it was locality, in other words, where you were standing, that was determinative of the constitutional rights of citizens, not their individual status as citizens. I will soon come to some cases and show you how the Supreme Court has applied that. In the case of Puerto Ricans, according to Taft, all that the grant of citizenship meant was that they could travel to the mainland and there, upon establishing residency, exercise all the rights of other citizens. The court in Balzac ultimately concluded that the right to trial by jury was not a fundamental right applicable to the citizens who reside in Puerto Rico. That also you will see how they apply it later on in my discussion to other citizens. You also know, I'm sure, if you've taken constitutional law, that the Supreme Court has since decided on several occasions that the right to trial by jury is a fundamental right. But in so ruling, the court bypassed its holdings in two cases that had been decided recently after the Insular Cases. One was Manchique versus Hawaii, decided in 1903. The second one was Rasmussen versus Alaska in 1905, in which the same issue, whether the people in those territories were entitled to indictment by a grand jury and trial before a petit jury. And they decided that they were entitled to it because they were citizens of the United States. I'm shortening up my remarks, but basically that's how I interpreted those cases. The court completely bypassed those cases and ruled that in the case of Puerto Rico, it was different because it was a long distance from the mainland, that it could be colonized by Anglo-Americans, et cetera, et cetera. In any event, it was one of the first, but not the last time, that the Supreme Court did not apply the rules that apply to the rest of the citizens of the United States. Now, I realize that that calling the United States a colonial nation, as I am doing, and has been done by several of the prior speakers, is repugnant to most Americans, and thus when I proceed to make that claim, I do so with some trepidation. As Americans, we do not consider ourselves within this anachronistic category. I thus apologize if my statements cause some discomfort among some of the members of the audience. But do you think that this reality is any less repugnant to those of us who find ourselves in the degrading status of second-class citizens merely because we live in a piece of land that has been, by judicial fiat, determined to be different than the rest of the United States? How do you think that this status sits with me personally, who, although a member of the second highest federal court in the nation, often deciding issues of national importance, am denied the right to vote for those who occupy the national offices who decide my destiny, and who pass the laws that I enforce, laws that permeate every facet of my daily life when I return to Puerto Rico tomorrow morning. Leaving aside the legal niceties that we are discussing today, does that make any sense to you? It certainly doesn't make any sense to me. UNESCO's Dictionary of Social Sciences defines a colony, quote, as a territory subordinated in various ways, political, cultural, or economic, to a more developed country, in which the supreme legislative power and much of the administration rests with the controlling country, which is usually of a different ethnic group from the colony. This definition fits the Puerto Rico-U.S. relationship like a glove. Because of the limited time that I have, I will only discuss the political subordination, although the economic subordination is equally compelling, or overwhelming, I should say. As I have stated, the U.S. citizens who reside in Puerto Rico have no vote for any national office, nor do they have any voting congressman in either house. The office of resident commissioner, our single so-called representative in Congress, has no vote in that body in the enactment of legislation. This office is, constitutionally speaking, a sad commentary on a nation that prides itself with being the bastion of democracy throughout the world. This office is, in polite terms, politically impaired. Where we treat it equally in the nation, in the same manner as the other jurisdictions, with our present population, Puerto Rico would have a larger congressional delegation than more than half of the states. And that is one of the principal reasons why Congress is not in any hurry to change the situation. I'll tell you an anecdote that I had that I experienced when I was chief judge of the circuit. I had to try to refurbish our courthouse in Old San Juan, and I had no political clout in Washington, so I went to one of my colleagues in the court who had been the fundraiser for a very powerful senator in Congress, Senator Chafee, who has since passed away. So he got me a meeting with Senator Chafee, and we resolved the issue of the courthouse very quickly. He turned over to the head of the GSA, who was sitting next to me. He said, "I want that building fixed." Guy turned white. He said, "Of course, Senator. I didn't know you were interested." And then I said, well, he's very busy, let's get up. And I started to walk out. He says, no, Judge, I want to talk to you about something. I had no idea what it was, but there was pending in Congress one of the interminable Puerto Rico status bills. And he said to me, asked me about it, and he said, well, I don't know if I can go for statehood. And when he said no, and he asked me, what do you think about statehood? And of course, everybody knows I'm a statehooder, so I thought I was being given the opportunity. I got up on my podium and I started giving my usual spiel, and I could see it was not penetrating one iota. And when I finally stopped, he said to me, I don't know if I can go for you, Puerto Rico statehood. I'm from Rhode Island, one of the original 13 colonies. We have 2 senators and 1 congressman. If you become a state, you'll have 2 senators, probably 7 or 8 congressmen, and they'll all be Democrats. Well, I learned the lesson in politics that day. The federal bureaucracy in Puerto Rico follows the same suit. It is appointed, controlled, and led from afar in a place where we have no political influence, and where we who are without electoral significance must go hand in hand asking for charity. Can it be seriously questioned that Puerto Rico and its citizens are totally subordinated politically to the United States? I don't see how. Particularly irritating, to say the least, but illustrative, are 2 cases involving Social Security in which the 2 cases are Califano-Torres and, there were 2 cases that were very related, and Harris versus Rosario. In Califano v. Torres involved the Supplemental Security Income, or SSI, which is a program for special benefits for the aged, blind, and disabled persons. The case went up to the Supreme Court. The Supreme Court, the woman living in Connecticut started getting those benefits and then moved to Puerto Rico. When she moved to Puerto Rico, the benefits were taken away from her because Puerto Rico did not come within the definition of the United States, according to the statute. She brought the suit, and the Supreme Court held that under the Insular cases, this kind of distinction could take place. And listen to the reasons they gave. The first reason was because the residents of Puerto Rico do not contribute to the public treasury. Now, in the case of Social Security particularly, this is a totally, I won't say insane, I will say only that it's just not the law. The residents of Puerto Rico pay full Social Security like all people under the jurisdiction of the United States. The second and third were related, but these were even more incredible. And that was the Supreme Court found that this would cost about $300 million. I don't know how many blind and aged there are in Puerto Rico. I find that figure high, but even assuming it was correct, inclusion, quote, inclusion of Puerto Rico residents in the SSI program might seriously disrupt the Puerto Rican economy. Yes, that's exactly how I feel about it too. This is an outrageous, and basing on the Insular cases. The best argument that has been made, I should say, the ripple stay of Justice Marshall in the companion case of Harris versus Rosario is worth repeating. The rationale that giving larger economic benefit relief to the needy would disrupt the Puerto Rican economy has troubling overtones. It suggests that programs designed to help the poor should be less fully applied in those areas where the need may be the greatest, simply because otherwise the relative poverty of the recipients compared to the other persons in the same geographic area will somehow be upset. Similarly, reliance on the fear of disrupting the Puerto Rican economy implies that Congress intended to preserve or even strengthen the comparative economic position of the States versus Puerto Rico. Well, I can't say any more than I already said about that. There are several things I would like to call your attention generally about the Insular cases. The first is, and there are a lot more than one, I don't have 13, I only have one or two. Not that I dispute the 13. The first is that the country was at the peak of the manifest destiny furor. As you know, manifest destiny was a theory which had racial, economic, geopolitical overtones, all of which basically was that the so-called American race was entitled to basically rule any place they could get hold of, and started from the Appalachians out until they got to the Pacific. When they got to the Pacific, they ran out of places to conquer, and therefore they started looking to other lands. At one time, there were actually exponents that go all the way down to Tierra del Fuego with this theory. I'm sure that the people in between would have objected to it, but that's a fact. So this had to do. This is the background to the Insular cases. The Insular cases, I feel, were the judicial approval of the granting of a legal basis for these theories to be put into effect. The second point, and I think this point cannot be understated, that almost to a man, there were no women on the Supreme Court at that time, almost to a man, the court that decided the original, particularly the original Insular cases, was the same court that in 1896, just a few years before, had decided the Plessy versus Ferguson cases. And you know, these are the cases that really give the legal basis for discrimination, separate but equal. That's an oxymoron, and that just doesn't exist. If it's separate, it can't be equal. So that was, those were the cases that allowed the court, in the case of the Insular cases, to allow the discrimination based on race. Again, in this case, because of the fact that they lived elsewhere, they spoke different languages, have different religions, et cetera, et cetera. The third point, and almost no one mentions this, but I think it's also an important point, is that the Insular cases were decided by a mere plurality. It was 5-4. And there were several opinions in the so-called plurality. The opinions that received the most unanimous votes were in the dissents. And this is something, in other words, it was a shaky situation. It was so shaky that in 1902, when Theodore Roosevelt had become the president after the assassination of President McKinley, and Justice Horace Gray, who was one of the members of the plurality, was retiring, before he substituted him, he asked Senator Henry Cabot Lodge, who was one of the cabal behind all of this territorial expansion, to interview and talk to Oliver Wendell Holmes from the Supreme Court of Massachusetts, who was being considered to substitute him, about his views on the Insular cases. And it was only after the senator assured the president that Holmes was in agreement with him that he named Holmes to the Supreme Court. In my opinion, there's substantial legal and constitutional reasons for challenging the present-day validity of the Insular cases, both because of their initial infirmity and because of changed circumstances. The first is, and I realize I'm going back to prehistory almost, but it's the way it works. The first is that the constitutional invalidity of the provisions of the treaty by which the United States acquired Puerto Rico. That is Article 9 of the Treaty of Paris, which states, the civil rights and political status of the native inhabitants of the territory ceded to the United States shall be determined by Congress. This is clearly contrary to the Constitution. Congress doesn't decide who gets what rights. The Constitution establishes them. And Congress can't change that by a law. It has to be done by constitutional amendment. The Constitution is the one that determines who got what rights. And this is not something that I invented. The dissent, Harlan's dissent, I mean, you don't have to be a rocket scientist to determine that a treaty cannot go against the Constitution. And this is what the Treaty of Paris intended to do. Justice Harlan and Downs said, the idea that this country may acquire territories anywhere on the earth by conquest or treaty and hold them as mere colonies or provinces, the people inhabiting them to enjoy only such rights as Congress chooses to accord them, is wholly inconsistent with the spirit and genius as well as the words of the Constitution. And more recently, Justice Kennedy in Boumediene stated the following, quote, the Constitution grants Congress and the President the power to acquire, dispose of, and govern territory, not the power to decide when and where its terms apply. And this is exactly what Article 9 of the Constitution urged Congress to engage in. There's nothing, furthermore, in the text or history of the Constitution in which the word colony is even mentioned, much less that system of government is made a part of what was established under the Constitution. And this is not surprising we had just finished, not we, because I'm not that old, the War for Independence had just ended, and it would be illogical for people who had just been fighting a cruel, long war to break their colonial chains, to turn around and establish a system of colonies. The Territorial Clause, which the Insular cases relied on as a source of power to create an American empire, did not, in fact or law, grant such power. And two cases decided before the Insular cases, one by Chief Justice Marshall, the Longborough versus Blake case. The Supreme Court decided the same issue as came before it in the leading Insular case of Gonzales V Bidwell, namely, whether the Constitution applied in a territory. In that case, involved the District of Columbia. Chief Justice Marshall, in clear and unflinching language, stated that the term, quote, United States, end quote, when used in the Constitution, included both the states and the territories, and that, quote, the District of Columbia, or territory west of the Missouri, is not less within the United States than Maryland or Pennsylvania, and thus the Constitution applied in the territories as well. The applicability of the Constitution in a territory came up again 36 years later in Dred Scott versus Stanford, this time in relation to the Due Process Clause of the Fifth Amendment. I realize that the Scott case is discredited for other reasons, and rightly so. It nevertheless was a law at the time, and it established two constitutional principles unrelated to the reason that I've just stated, but related to the subject of today's discussion. The first principle is that the United States lacks constitutional authority to have colonies or to hold territory in a colonial condition. As the court stated, quote, Chief Justice Taney, there is certainly no power given by the Constitution to the federal government to establish or maintain colonies bordering on the United States or at a distance, to be ruled and governed at its own pleasure, nor to enlarge its territorial limits in any way except by the admission of new states. No power is given to acquire a territory to be held and governed in a permanently colonial character. The second principle established by Scott deals with the reach of the Territorial Clause, which, as you know, is the one that's claimed by Congress as a source of power for ruling its colonies. And this was the second principle established by the Scott Court. Quote, plaintiff has laid much stress upon that article, that is the Territorial Clause, in which the Constitution confers on Congress the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. But in the judgment of this court, that provision was intended to be confined to territory which at the time of the independence from Great Britain belonged to or was claimed by the United States, and that is the Northwest Territory. That's what it's referring to there. And can have no influence upon territory acquired, thereafter acquired from a foreign government. It was a special provision for a known and particular territory and to meet present emergency and nothing more. One of the things that I find disturbing about the insular cases is the way that the Supreme Court has applied, and I'm talking not about the Supreme Court back in the Spanish-American War, I'm talking about the Supreme Court in recent times. Right after the Second World War, two wives of a serviceman, one in England and the other one in Japan, murdered their husbands. At the time, they were tried before courts-martial because the law permitted anyone who accompanied servicemen, they were subject to the military code of justice. And they were tried, they were indicted, they were not indicted by a grand jury, and they were not tried before a petit jury. The case, they were then brought, they were sentenced to life imprisonment. They were brought to the United States to serve a sentence, and they filed habeas corpus. The case went up before the Supreme Court. The first time it went up, first time it was argued, the Supreme Court held that the convictions were valid under the insular cases. There was such a furor. There was a decision, one of those June decisions. There was such a furor caused throughout the general public that when a request for rehearing was filed, it was granted. And it so happened, in between, Justice Brennan was appointed to the Supreme Court. Well, the Supreme Court rejected those convictions and held that they were American citizens, even though the trials and the accusations and the crimes were committed overseas. Locality, here we go back to locality, it wasn't applied to them. So here you have the same situation, asking for trial by jury. Entitlement to trial by jury, as you had in Balzac, as you had in other cases before that involving the Philippines, etc. And the Supreme Court ignored them altogether. So the Supreme Court has been selective in its application. There was language, by the way, from Brennan and other Justice Black when they decided those cases. There was language that gave some hope to the possibility that they would reverse or do something with insular cases to put them away forever. But this has not happened. The insular cases have continued, and particularly Balzac has continued to be applied and relied upon by the Supreme Court in several cases since then. There's one last issue that I want to cover before I finish, and this regard to the violation, in my opinion, that is existing of international treaties. The ICCPR, and there are other treaties, but this one is very, very specific as to what it requires of the signatories. It was approved, it was ratified by a Senate, and I will just read to you several of the provisions that I think are more important. The United States undertook, quote, to respect and to ensure that to all individuals within its territory and subject to its jurisdiction, the right to vote without distinction of any kind, end quote. And agreed, quote, to take the necessary steps in accordance with this Constitution, with its constitutional process and with the provisions of the present covenant to adopt such laws or other measures as may be necessary to give effect to that right. Notwithstanding this unequivocal language, however, the executive branch, rather than comply with its mandate, has vigorously opposed the enforcement of these treaty rights, a position with which the courts have repeatedly cited, holding that this treaty is not self-executing and does not create private causes of action. I disagree with that to begin with. If you read the language, I cannot imagine any language that grants individual rights more decidedly than that one, but that's what the courts have decided. This outcome clearly ignores the fact that the treaty itself establishes the affirmative obligation of the United States, quote, this is in the treaty, this is treaty language I'll read, quote, to ensure that any person whose rights are recognized in the ICCPR are violated shall have an effective remedy, end quote, and further provides that such persons, quote, shall have his or her right determined by competent judicial authority and develop the possibilities of judicial remedies. Now, the courts have, at this point, all said that individuals do not have these rights and cannot enforce them in court. But that does not change the fact that these are valid treaties approved by the Senate, and they are, under the Supremacy Clause, the law of the land. This is still the law of the land. Individuals at this point cannot enforce this, but this is the law of the land. The United States is in clear violation of what, in my opinion, is the law of the land. Although this completes my official presentation regarding the insular cases, I am compelled to add a brief postscript, which I have pompously labeled my Harvard pronouncement. In 1974, Justice Hugo Black stated the case more eloquently than I possibly could. He said, no right is more precious in a free society than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. The reason why I'm making this additional statement is because I believe, as you will see, that there is a need to spark, to urge, to Congress into action. And the way to do this, in my opinion, is by actions that I will describe in a few minutes. Given that the citizens of the United States living in Puerto Rico have no political power, and that the courts have turned their backs on Puerto Rican rights as citizens, they may soon have no alternative but to look for other peaceful avenues of obtaining relief from these enduring inequities. This is particularly the case given that in a recent referendum, a majority of the Puerto Ricans voted to reject the continuation of our denigrating colonial status. It is now unassailable fact that what we have in the United States-Puerto Rico relationship is government without the consent or participation of the governed. I cannot imagine a more egregious civil rights violation, particularly in a country that touts itself throughout the world as the bastion of democracy. This is a situation that cannot and should not be further tolerated. Although there is pending before Congress possible legislation to break this Gordian knot, unfortunately, judging by past history and considering what we have seen of Congress's performance in recent times, one would have to be optimistic beyond reality to expect that anything significant will emerge in the foreseeable future. Given the prospects of the continuation of our interminable status quo, Puerto Ricans may reasonably come to believe that the time has come to take some more noticeable actions than in the past, because there exists and has existed a major civil rights issue that has been lingering for more than 100 years and does not seem to get resolved by the exercise of only patience and good manners. One step that the U.S. citizens of Puerto Rico may consider is gradually engaging in time-honored civil rights actions, of which there are many successful examples. One that comes to mind, because economics, that is hitting at the pocketbook, seems to bring about results and attention to the issue, is the use of economic boycotts to attract attention to ongoing civil rights violations. This is a mode of protest that has been used successfully to correct civil rights violations, starting with the Boston Tea Party, to Mahatma Gandhi's March to the Sea, to boycott the protest the salt tax by the British in India, to the bus boycott in Montgomery to protest segregation in the Rosa Parks treatment by the state authorities, to the California grape boycott, etc., etc. This is not a call for drastic action, but rather for recognition of the simple fact that Puerto Rico's consumers represent one of the most important markets for the United States products, with its citizens constituting the largest per capita importers of U.S. goods in the world, with $35 billion in annual retail sales alone. Additionally, some of the U.S.-owned companies conducting business in Puerto Rico are among the most successful in the entire nation, against which concerted economic action would quickly attract attention. When we add to the almost 4 million consumers in Puerto Rico the equal number of Puerto Ricans residing throughout other parts of the United States, we can begin to imagine the potential scale of such actions. And of course, we ought not to forget the larger Latino constituency, which is now the largest minority in the United States, and which could be sympathetic to correcting the inequalities to which the U.S. citizens of Puerto Rico are being subjected merely because they reside in Puerto Rico. Lack of political clout can be substituted by economic impact, which in many cases is equally or even more effective more effective. There are, of course, others who may be sympathetic to the plight of the U.S. citizens residing in Puerto Rico because of their own experiences with inequality. So the number of possible actors is truly impressive. I believe economic pressure is a logical avenue to consider, because if experience teaches us anything, it is that where there is a just cause that the citizens can sympathize with, combined with national attention and economic concerns, the chances of ultimate success increase exponentially. Thus, because the national judiciary and legislature continue to turn a blind eye to the present injustice, we should not be surprised if Puerto Ricans seek a more sympathetic and powerful audience. Mine is but an idea that I place in the public forum. How these civil rights actions might be carried out, if at all, is beyond my expertise or power. But the suggested ideas bear consideration by those in a position to transform them into action. There's now in circulation a stamp. I collect stamps. There's now in circulation a stamp that says equality forever. And it seems to me that the post office is way ahead of the rest of the country. Thank you so much for your patience in listening to me.
The judge has agreed to take some questions, and if you want to ask a question, would you come up to a microphone, identify yourself, and make it a brief question?
You don't get a chance to cross-examine a judge's office, so shoot.
Judge, my name's Howard Hills. You know, I think that listening to this morning's discussion and then that wonderful address you just gave, one of the things that might help the people who are learning about the Insular cases, you know, we all know what's wrong with the Insular cases as they applied originally when Downs was handed down. One of the overlooked overlooked comments in the court's opinion in Downs was that these decisions that we're making about Puerto Rico, the Philippines, apply in the period before Congress makes a decision about citizenship. And that's been very overlooked in the Downs decision. So my comment would be, and then I'd ask you to comment, sir, if you would. We all know what's wrong with the Insular cases as they apply to the territories before citizenship was granted. During that period, the case that people seem to forget about is Gonzales V Williams, 1904, in which they defined the status of people in these territories when they weren't citizens. And they said they are nationals. They're subject to the national protection of the United States. So then later, Congress came along and exercised its authority under the Uniform Naturalization Clause of Article 1, Section 8, and conferred citizenship on them in 1917. And so my question to you is this. Up until the Insular cases made an exception from the Northwest, you know, Christina Duffy was talking this morning about the model of deciding status and citizenship through a constitution, which was the Northwest Ordinance model. And then we made an exception for these new territories because they were not going to be incorporated. So that exception applied, and in some ways it worked in the sense that it led to, for those territories that were going to become independent, the Insular cases in a way worked, although in a very unorderly way. But so then the exception suddenly was applied after Congress granted citizenship.
Say what your question is.
Yeah. So my question is, isn't the Balzac decision really not one of the Insular cases? Isn't the Balzac decision actually a deviation from the Insular cases in the sense that they originally applied only to non-citizens, and at the point where citizenship was extended, shouldn't the Alaska Rasmussen case and the Hawaii Mankichi case, shouldn't they have been applied, and shouldn't have their Insular cases status of Puerto Rico ended when Congress conferred citizenship?
Well, I basically agree with that. I mean, Balzac case is, you could say it's not part of the Insular cases. It's part of a continuum from the Insular cases in terms of the Insular cases are decided before citizenship. Balzac is decided after citizenship. One thing that definitely should be overturned is Balzac the basis of its decision, basically that jury is not a fundamental right, is now no longer, for a long time, a law of the United States. At the very least, it should be overturned for that. But the idea that all that citizenship, it's probably the United States is probably the only country where citizenship only allows you to travel from one place to the other. I'm probably saying something that's not true, but I don't know any other. Any other questions?
My name is Juan Jimenez.
Oh, how are you? I haven't seen you for a long time.
It's my friend of over 60 years, fellow alumni.
You look the same.
Good to see you. You know, I do not perceive at all that the average Puerto Rican feels aggrieved, feels that he has been deprived of any civil rights. And if anything, it's quite complacent of the present condition. And I ask, under what conditions and how, what could be the catalyst that would provoke that, well, if you might put it, revolutionary source in order to be able to challenge the present status and try to obtain that right which belongs to them as citizens of the USA?
I think that's a very good question, and I don't know how to answer it because I think it's outside my area of expertise. I mean, I'm not a politician. I've never been a politician. I'm not I can't promote people changing their views or doing anything. But it seems to me that one of the reasons why they are not, obviously the Insular cases is not something that is commonly discussed in Puerto Rico by anybody except us eggheads. But what people don't understand is that if Puerto Rico had 2 senators and 8 congressmen, the benefits that they would receive as individual citizens would be exponentially more than what's happening now. That to me is not the reason for changing them. I think that's a very superficial reason. But I think the average person would think twice about it if that was explained to them, or I assume, I don't know. I'm sorry, I'm not answering your question very well.
No, I know that at least one of the political parties, the PNP, has made that point quite clearly, the fact that we would gain definite additional powers by having additional representation in Congress. But still, I think that emotionally, the average Puerto Rican is quite complacent with the present status. And
I'm not so sure I agree with you on that one.
Unless they have the emotional feeling, like let's say the independentists do, that they are really gung-ho about their feelings.
Well, we had a plebiscite recently, and over 50% of the Puerto Ricans said that they were not in agreement with the present status.
Yeah, but it's changing from one party to the other party versus really challenging, let's say, trying to acquire those civil rights, let's say, voting rights.
Election results do not have footnotes. They don't say because half of the voters had a headache and couldn't go vote, or they went to the beach, etc. Election results are final, in my view. The outcome is there. It's mathematics. It's either this or that. And the most recent, I'm not saying that if there was another one, it might not change, but the most recent poll that we have is the last plebiscite, and over 50%, I think it was 51 or 52% of the 54, okay? Well, good. Thank you.
Hello, my name is Tommy Jacob Nicocelli. I'm a medical doctor in town. My question is about sailing.
Sailing?
You are an Olympian, right?
Yeah,
you went to the
that we
Olympic
can talk
Games. You went to the Olympic Games at the age of 43. Am I right?
Me?
Yeah.
Was I that old?
That's in 1976. You were 43 years old. You
No,
were-
actually, my first Olympic was 1964.
I understand that, but at the age of 43, you went to the Olympic Games.
Oh,
too.
yeah, right.
It's a big deal. Now, congratulations. You are an Olympian, which
Obviously,
is...
you didn't see the results, so you wouldn't be congratulating me.
I mean, it doesn't matter. You were an Olympian, and once an Olympian, always an Olympian. So the question is about that. It's a big deal being an Olympian, being a sailing. You're a professional sailor. What did you learn from sailing, from being a professional in that area to being a judge? And then how can you expand? Because in life we all do things that are together. So from sailing, from being an Olympian, how can you expand this to being a judge? Number one, and number two, I'm a Latino myself, so I'm glad that you are fighting for this, and somebody like you, I think you're going to make it. I think you're going to get the results you want. Keep it up.
Thank you. Do I answer?
The question is, how do you expand being an
Well,
Olympian?
I was discussing this with
to a
somebody
judge?
this morning, I think at breakfast. I think that judges should do more than just look at law books and discuss law. Because life is not just about law books and discussions about law. Life has to do with a lot of things, and judges have to do with life eventually. So the more, the broader your experiences are outside the law, I think the better you can help the public in deciding issues of law.
So, in terms of election law, I would like to ask you if, in the first question of the referendum that was in November 6th, did it psychologically change the way that people were going to vote? Because from my point of view, a lot of people in the island are not very familiarized with the word territory. So maybe I'm not sure if the people voted against the status quo in terms what if the first question was drafted differently? We won't really know if they rejected that if we put it the free associated state or ELA in the first question. For example, I know people that psychologically were already thinking, no, I'm gonna vote no in the first question so that I can vote for another option in the second question because they fear that the statehood option will win. So in terms of election law, do you think that the first question abruptly violated the intention of the people of Puerto Rico to exercise their vote?
Well, the first problem with your question is how do you find the intention of any big group except by holding a plebiscite? I mean, any issue you can frame in 10 different ways. Okay, it's impossible for me or anyone, except when they have an axe to grind, to speculate as to what could have happened. I can't comment on what could have happened. I can comment on what happened. I can work with facts. I cannot work with speculation. The facts are there. There are no footnotes. It says 1, 2, 3 on one side and 1 on the other, or whatever numbers my friend here will give me again. But that's it. I understand where you're coming from. I just don't know how to answer that except how I just said.
No, I know that election process cannot be repeated the same, but I think that the people were misguided in some sense.
Probably.
Thank you.
Well, I see there are more questions, but we're going to have to take a break. But could you all join me in, again, thanking Judge Torruella? Thank you so much. It was really, really excellent. So the
my family.
next panel will resume at 1:30.